Very good. I see Ms. Berger. I see Ms. Valdez, and I think we are ready to go. So Ms. Berger, the time is yours.
Thank you, Your Honors. Erin Berger from GLC Law on behalf of the appellant, Mr. Mendoza. As the record reflects, Ms. Brunilda Cruz died during the pendency of the underlying action, so there's just one remaining appellant. We are here today, and I would request 5 minutes of rebuttal, Your Honor. Mr. Mendoza is here today asking the court to reverse the entry of summary judgment that was entered in favor of Security First because the trial court erred in finding that the insurance company was entitled to summary judgment as a matter of law after concluding that the affidavits that were presented in opposition were inadmissible and insufficient. The appellant also contends that the affidavits were sufficient to demonstrate the existence of genuine issues of material fact. And we've raised a couple of other issues that if I have time, I'll get to, but those are more minor issues, Your Honor. The first issue that I'd like to address is the treatment of the affidavit of Mr. Mendoza's expert witness, Mr. James. The affidavit was presented in accordance with Rule 1.510. And if you take a look at the allegations, Mr. James testified, or he averred, that the information in the affidavit was based on his personal knowledge. You'll note that in his affidavit, he does not state that the report that he relied upon, he had personal knowledge of, or that he inspected the property himself. The statements in the affidavit were made on personal knowledge. The judge rejected his contention or his claim that he had personal knowledge of the events that were claimed in the affidavit, and that he was not competent to testify as to his asserted attestations.
What did his personal knowledge consist of in the affidavit?
Your Honor, his personal knowledge was limited to a few things, and let me pull it up so I can tell you directly. It's on page 318 of the record. He says his name, that he's over the age of 18. He has, he's a certified building contractor and other, professional certifications and certificates that he holds, where he works, that he completed the repair estimate that was attached to it, and that he based his estimate on Mr. Long's report. He said what his conclusions were based upon that report, and what he believed the damages to have been caused by. Now, again, he's not stating anything that Mr. Long stated. He's stating what his analysis of Mr. Long's report was. And I think that, from my interpretation of the judge's issues with the affidavit, he seemed to suggest that because the affidavit was referencing Mr. Long's report, that he could not establish personal knowledge because he didn't actually inspect the property. But as I've mentioned in my initial brief, and as I've not mentioned, but briefed the issues with regard to expert testimony, is that experts can rely on hearsay. And we're not just talking about like the cases.
Let me perhaps go to what I think is the most salient point.
Sure.
Where does anyone on your side of the case dispute that or establish that the angle valve failed?
Neither Mr. Long nor Mr. James were able to inspect it. There was record evidence that the angle valve was turned over to the insurance company's expert, Mr. Nierig, and they inspected it. There wasn't ever anything. So
assuming that they did not, or not assuming, I think we all agree or understand, they did not inspect the valve.
Right.
And the report from Triad that Mr. James relies on basically says that it's relying on the history or the information that was provided to them.
Right.
So what other than conjecture, what established that the angle valve leaked that created an issue of fact in light of the testing that the other side presented?
Right, and certainly that's very compelling evidence, Your Honor. The affidavit of Mr. Mendoza, who lived at the property, knew his property, and knew if he was having any leaks prior to this time, he averred in his affidavit that this was a one-time thing. He explained that
But the the theory that you relied on, or that your client relied on, was that the angle valve leaked, correct?
Correct.
So what established that the angle valve leaked? What competent substantial evidence, someone who knows what an angle valve is and what it does and whether it's working properly or not, what established that it leaked?
Your Honor, I don't believe that there's anything directly establishing that fact, but I do believe that there's circumstantial evidence in the record to suggest that there's an issue of a question of fact with regard to whether or not that is, a question of fact as to the cause of the leak, because what Mr. Nierig does acknowledge is that there was water damage to the property. And obviously their report suggests, or he determined that there wasn't an issue with the angle valve, but Mr. Mendoza testified in his affidavit that he believed that that's what it was based on what he was told by the people who changed it out for him. And, you know, if they had, there's a question of fact as to whether or not something could have come from Mr. James's review of it. And I would point your honors to the case that I cited, in Lopez versus Wilson Art LLC. It's the 5th DCA case, 275 Southern 3rd, 831. In that case, the court was faced with the summary judgment issue where they had a video of an accident that the court believed, you know, pretty much conclusively established that the evidence offered in opposition could not be valid. But based on their standard and the standard that this court should apply upon review of summary judgment, you know, the circumstantial evidence and the other evidence offered in opposition to this, even if the other side, even if the moving party's evidence was compelling, constrained the court from affirming that final judgment, because there were some scintilla of evidence, as this court has found, that, you know, something else could come further down the road. And
Ms. Berger, we've got a decision called Panzera, which specifically holds that any evidence to be considered by the court must be admissible evidence. So it's clear in this particular case that everything that was inspected was behind a crawl space in this room and could not be seen. It wasn't conspicuous to the owner because the wall had to be removed, and then this valve had to be removed. It was never tested by you. You waited till the last minute, but never got it. And this was inspected by Mr. Nierig, who personally inspected the premises, and then made a determination based on his engineering experience that there's nothing wrong with the valve. So isn't the issue the operability of the valve? So how does Mr. Mendoza know that the operability of something behind the wall, and you can't even see any damage unless you open the wall? And his affidavit appears to be conclusory. The damages were not a result of a long-term leak or constant repeated seepage. What is that based on? Doesn't give us any personal knowledge as to why he's reached that conclusion. How is that admissible as an opinion, a lay opinion? Plus, it seems that Mr. James and Mr. Long seem to be internally inconsistent, where Mr. Long, who's the only one that did the inspection, says it's consistent with a reported plumbing leak. And then Mr. James kind of extends himself and says it was a leaky angle valve that he didn't even inspect or even test. So how's that admissible?
First, I would say that the admissibility of the report and the affidavit were never actually raised by the insurance company. They were raised by the trial court on its own.
Well, that's his job.
Right.
I mean,
and Mr. James's testimony was based on his experience as a certified building contractor, a mold remediator, an independent adjuster, and a certified appraiser, and a certified umpire for appraisal issues. And I think that you can't discard that he also has experience from which he could say, this is information that's consistent with things that I've seen before. You know, he said he concluded that these things were result of these leaky angle valves, which he reviewed. He did a peer review. You know, Mr. Long apparently works for the same company. You know, it's unclear necessarily from the affidavit if he assisted with it, but the report does say.
But neither one saw the original angle valve nor tested it, nor even bothered to obtain it. Neither one. They go
I don't
in
know
and
that
they
there's
say,
record.
we see
Sorry.
a replaced valve there, and we see evidence of some water damage. That's it.
Correct. That's what the record shows. I don't think there's record evidence to say that Mr. Mendoza never tried to get the angle valve back. I think he attested in his affidavit that they gave it to him and assumed that they would be getting it back.
We had 2.5 years to get it. He didn't, there's no pleadings to request it back. So,
Right, but the insurance company didn't, prove that there was no request. There's an issue of fact maybe as to whether or not that could have happened or did happen.
well,
They
you
didn't
didn't
establish
raise that below at all.
No, it was not raised below, Your Honor.
Okay.
But they did, he did mention it in his, it was raised in the response, and he did mention in his affidavit that, it was given to them and they assumed that they would get it back. But again, and you mentioned Mr. Mendoza's statements about the event, and I'm, his affidavit potentially reads as conclusory statements, but he's the one that lived in the property, and this could be interpreted and should be inferred in his favor on summary judgment that he was stating that this was a one-time thing as far as he knew, and that he wasn't aware of any persistent leaks. He lived in this property.
I'm sorry, ma'am. I'm sorry you froze up for a little bit.
I'm sorry, Your Honors. I just was saying that his statements could be construed as, although perhaps written in sort of conclusory form, because it potentially could have been written by his attorney, but the inference should be made in his favor here that he was testifying that he did not experience any leaks before that he knew about, that the damage that he discovered, it did not appear to be an ongoing thing. And again, the record does show that the insurance company did find that there was water damage. And although they found that the angle valve wasn't the issue, I think the affidavits that were offered in opposition did establish that perhaps there's an issue of fact as to what did cause the damage, if both parties are acknowledging, and it's undisputed, that there is water damage.
Do you agree that the complaint set out a claim based on a failure of the valve?
The complaint states that he suffered a water loss due to water discharge in the bathroom. It doesn't mention the angle valve.
I thought it did. I'm looking at the complaint right now. Perhaps if you point me to where you're referring to, that will remind me.
Sure, Your Honor. I'm on page 7 of the record.
Paragraph 7, it says, a loss due to water discharge in the bathroom, a covered peril, and then talks about the estimate and so forth. But I thought later in there was an allegation that the cause of the leak was the valve, or perhaps that was in the affidavit. I think it may have been in the affidavit then.
Yes, Your Honor. I don't believe that was in the complaint, but I can look during counsel's argument because I don't want to misrepresent the record to Your Honor.
No, it does say in paragraph 13, the policy provides coverage for loss due to water discharge resulting from damaged plumbing mentioned herein. And I'm not sure that there's a specific reference in the complaint to the valve, but I think that was what the affidavits and the motions were directed to, correct?
Yes, Your Honor, I believe so, because I believe that in the NERG report, he states, and Mr. Mendoza did testify in his affidavit that his deceased wife had provided a portion of the plumbing to NERG, and he concluded that that's what it was, I believe.
But the breach is basically because of water discharge resulting from damaged plumbing. And
correct,
so
Your
the
Honor.
only issue that was presented to the trial court was whether or not the damaged plumbing was the purportedly defective valve, right?
Correct. I believe based on Mr. NERG's conclusion that that's what he was provided, and that's what he inspected. So, and that's why I argued previously, Your Honor, that I think there's a question that remains as to what, both parties agree that there was water damage, but the insurance company has only conclusively established by their affidavit, or they allege that they conclusively established that the angle valve was not the cause of it. But I don't believe that that rules out that there's still a covered loss here. And there remains a question as to what caused the loss.
Ms. Berger, that takes us to the 5-minute mark if you want to reserve the rest for rebuttal.
I would like to. Thank you, Judge Silverman.
You're welcome. Ms. Valdez.
Good morning, Your Honors. May it please the court, Alexandra Valdez on behalf of the Appalachia Security First Insurance Company. Your Honors, I think that it's really difficult to dispute that the allegation and the claim that was made by the plaintiff in this case was that the angle stop valve was the cause of the damage here. To Ms. Burr's point that the insurance company does acknowledge that there was water damage, this is part of the basis for the insurance company's denial of coverage. The water damage that was identified by the insurance company during its investigation by its expert, Mr. Nierig, was historical water damage that had existed for a period preceding the policy's term. And was also the result of deferred maintenance. 2 points of exclusion in the policy, which form the basis of the company's denial of the claim. To address Mr. Mendoza's affidavit, I mean, I think that the court is aware, it does include conclusory statements relating to things that, as Your Honor, Judge Sleep pointed out, were behind a wall, and it's difficult to say how the insured could attest that they were not the result of pre-existing water leakage, but rather a one-time event when it's something that wouldn't be visible to him to begin with. With respect to the issue of the stop valve, there's no evidence in the record that the insured, requested this return or made any effort to secure the return of the valve to do its own testing. As Your Honors pointed out, this summary judgment had been pending for over a year. At no point did, until the 11th hour, did the plaintiff seek to have their own expert investigate the issue and conduct its own testing. I believe it was mere days before the actual summary judgment hearing, which had been reset on at least one prior occasion. So I think that, plaintiff had ample opportunity to secure what evidence it would need, and it failed to do so to counteract the summary judgment evidence put on by the insurance company. And the summary judgment evidence put on by the insurance company conclusively showed that the valve was in fact not defective, that there had been historical water damage, that there was no damage to building materials, and all of these points supported the insurance company's denial of the claim based on the exclusions in the policy. Again, plaintiff failed to put on any sufficient counter evidence to counteract these points. With regard to Mr. James's affidavit, again, they never inspected the valve. They never saw the valve, before it was replaced. So it's difficult to say how Mr. James could have come to the conclusion that the valve was the cause of the water damage when he neither inspected it nor ever really saw it. But he also didn't inspect the site personally, which goes to the trial court's point that he lacked the personal knowledge to come to these causation conclusions. And Mr. Mendoza lacked the expertise to be able to come to those similar conclusions. So neither of these affidavits were sufficient to create an issue of fact or to counter the insurance company's evidence, which did conclusively disprove Mr. Mendoza's theory of the case. And so for these reasons, as well as those contained in our brief, we believe that the trial court reached the correct conclusion here, properly granted summary judgment in this matter in favor of Security First. And if the court has no additional questions, we would rest on our brief and ask this court to affirm.
Ms. Berger, back to you.
Thank you, Your Honor. Just touch on a couple of points made by Ms. Valdez. The judge did not rule on the issue of their affirmative defense based on the exclusion of damage as long-term. Also, I don't believe they even raised that in their motion for summary judgment. The question of fact that is created by Mr. James' affidavit concerning the one-time event versus long-term event is that he concluded that based on his experience, the damages that he saw from the pictures and Mr. Long's inspection were consistent with a one-time event or not. They were not consistent with a long-term event or a long-term leakage. With regard to the timing of the affidavits and with regard to the timing of the inspection by Mr. James, that goes to the issue that we raised in our initial brief, that there should not be a consideration of the weight or credibility of the evidence that was presented in opposition. Whether or not, plaintiff should have done an inspection before, 2 days before, or a few days before the hearing, that goes to the weight and credibility that would be given to his testimony, not to the admissibility of it. And we raised that issue in the brief, that the court improperly weighed those issues. And I would just point out a few other statements in the final judgment that suggest that he did weigh the credibility. He did make determinations based on the weight and credibility of the evidence. He highlighted in his review of Mr. Nearing's affidavit, that what his report revealed in terms of the cause, and then also made a few remarks, or made a few findings, not remarks, made a few findings with regard to, and made comment about the timing of the inspection and the affidavit. His statements, he said on page 413 of the record, to claim that he has personal knowledge of all the facts stated in his affidavits is misleading at best, downright false at worst, which suggests that there was more consideration other than the admissibility of his testimony. And finally, with regard to Mr. Mendoza not having the requisite expertise, again, I would just suggest that the inference that should be afforded to Mr. Mendoza is that, he was the person that lived in the property. He's not required to be an expert to provide testimony in opposition that would create an issue of material fact. And I would direct the court to the case that was cited in the initial brief, Four Corners Insurance, Inc. versus Sun Publications of Florida. And there, an affidavit of a business owner was offered in opposition to a CPA, an expert, in testifying to lost profits. And the court found there that the affidavit of the owner was sufficient to create a genuine issue of material fact, even if his testimony would be insufficient to sustain a verdict. It was enough to create a genuine issue of material fact. And I think the circumstantial evidence that was offered in opposition to the insurance company's affidavit and summary judgment evidence was sufficient here to create a genuine issue of material fact, and we would request that your honors agree and reverse the final judgment.
Very good. Thank you very much, Ms. Berger and Ms. Valdez. For my colleagues, we will confer in about 10 minutes or so, and that concludes this session of the Second District Court of Appeal remote oral argument.